Right, I think I'll make a start. Welcome everyone to the first part of the Tech Dispute series, Hong Kong 45 Tech Dispute series. This series will explore technology disputes and looking at elements when considering resolving disputes and the use of arbitration. The first part and the first session today will be an introductory session into what tech disputes is, and also look at the procedural and substantive considerations when considering and running a technology dispute. This webinar will be split into two parts. The first part will be myself and Gotcha, who will commence with a presentation to explain what technology disputes is. My name is Jennifer, and for some of you who may know, I'm a Hong Kong 45 committee member. I'm a technology and data specialist at St Masons in Hong Kong, with a focus on technology disputes and technology arbitrations. And I will be covering elements from a private practice angle in the first part of the presentation. I'll be joined by Gotcha. Gotcha is a counsel in the HK45's arbitration team, who will be sharing the HK45 stats with us in the first part of today's webinar. We will then hand over to Gideon and Lucy for the second part, where they will discuss the procedural and substantive issues faced from the perspective of a counsel and also arbitrator. Gideon is a barrister at Four Pump Court, specialising in technology and telecommunication disputes, and has a wide range of technology arbitration experience. Lucy is an arbitrator and counsel at Martinez Arbitration, and she has a wealth of industry experience, including technology. After the second part is over, there will be a question and answering section. So please use the Q&A box to type in any questions you may like to ask the speakers. Before we begin the presentation, I would like to thank the audience for joining us. And it's great to see not only participants from Hong Kong and Asia Pacific, but also Africa and Europe and the UK as well. We will now start the first part of the session. Thank you. So what is technology disputes in practice? In my line of work, it is split into two broad categories. We'll be normally dealing with commercial disputes for TMT clients, and those are technology, media and telecommunication clients. And these can range from breach of contract issues, shareholder disputes and advising on termination. There would also be technology specific disputes to do with software licensing, IT projects, data and JV collaboration disputes. I will now hand over to Gotcha to explain how the institution would define tech disputes. Over to you, Gotcha.
Thank you, Jennifer, for the introduction. It is difficult to define the cases due to its nature, and they're often defined as IP or finance, but with the developments in technology and emerging subcategories, I think this identification is going to change. At HK45, we conducted a study and gathered all the cases involving technology companies, as well as disputes related to technology for the period of 2016 to 2021. We understand that there are two main categories of disputes. First, directly related disputes. This means that the dispute arises out of the technology itself. It includes matters of intellectual property, information telecommunication, licensing, or fintech materials. For example, design and purchase of a software or design of a new technology for a mobile phone or visual services. Second category involves indirectly related disputes. This means that the dispute arises out of something else that surrounds the technology. This category includes corporate and finance matters, encompasses use and development of technology. For example, purchase and production of a medical machine that involves two biotechnology companies, loan agreement executed for a tech project, or sale of shares in a technology company. For the purposes of this event, I'm going to provide numbers to you for all the cases, both direct and indirect disputes, to understand the nature of the cases. To date, we have identified 116 cases. Before we move on to the next slide, Jennifer, would you like to chime in?
Yeah, for sure. And I totally agree with what you said. I think where it is directly related, it can be summarized as either about the technology product or about the project itself, such as an IT digital transformation project. These are the core tech disputes. And you may have come across this already in the Queen Mary report our firm did on technology disputes. From this presentation, we are hoping that the audience will learn more about technology disputes. And this is much wider than the traditional IP and licensing type of disputes that you expect to see, because IP is a specialist area in its own right. Gotcha will now take us through the different categories of technology disputes and the cases seen at HKIC.
Thank you. We can stay on this slide. As I mentioned earlier, it is difficult to describe technology disputes because of the broad term. Therefore, whilst categorizing, we noticed that one dispute may enter into multiple subcategories. For example, design and license of a software. How would you describe it if the claim is in relation to defect in the software and violation of license? Or a dispute arising out of a software agreement for trading services for a bank. How would you describe this one? Normally, we would describe these type of cases as license or sale of goods. However, with increase in the area, we started to use other terms such as fintech, biotechnology, or gaming. In order to be up to date, we evaluated our cases from different angles and created these subcategories on the slide. One case may fall under multiple subcategories. This is natural when we think technology encompasses a wide range of products and services and broad range of sectors. But I should note that, I should definitely underline that the overlap only applies to categories, not to the total number of cases. Now let's demystify some of the categories. The big chunk in this pie is in relation to sale, purchase, distribution, and corporate disputes. The category name is including disputes arising out of distribution agreements. For example, a case arising out of a distribution agreement between a telecommunication company and a technology company for production and distribution of its cell phone in the technology company's jurisdiction. Or this category may involve corporate matters. For example, a dispute arising out of a share purchase agreement where a technology company bought shares of another technology company. Or sale and purchase agreements, for example, sale of software, as I mentioned earlier. The second category is fintech. This category also involves cases in relation to cryptocurrency. Since one of our case summaries at the end of this slide, at the end of this presentation is going to be about cryptocurrency, I would like to focus on something other than cryptocurrency for fintech. There is this case where a bank and a leading technology solution company entered into an agreement where respondents affiliate granted license of a trading software and user documentation to the claimant, the bank. The dispute arose out of the respondent's alleged incompliance with the agreement. I think you understood the gist, so I would like to focus on another example about gaming and media disputes. The news highlights different success stories of gaming companies frequently nowadays. From the institution, we also see their disputes arising. For example, in a case we have, claimant is a mobile game developer and develops a video game designed for mobile devices in which users compete. Respondent is a publisher of video games internationally. The parties entered into an agreement for respondent to increase publicity of claimant's game overseas by being its publisher. Claimant initiated an arbitration against respondent for alleged wrongful termination of the contract. Another example is also quite interesting, this time involving a media platform, and it is between a streaming company and an individual. According to the agreement, respondent allegedly undertook to perform live streaming of a game in claimant's platform. Claimant initiated the arbitration about respondent's alleged breach of the agreement by stop screaming at claimant's platform and starting streaming at a competing platform. For the interest of time, this is all for this slide. Jennifer, before we move on to the next slide, would you like to chime in?
Yeah, for sure. And I think you've covered the spectrum really well, obviously looking at the most common type of technology disputes in the kind of digital transformation projects and the purchase and sale of software. So those are like the corporate ones that you spoke about as your first example. And some of these matters in practice would be resolved at the pre-action level. But the most common pitfalls you would expect to see here are functionality type of disputes where there are issues with the software itself, and categorization of issue, whether it's a bug or a defect. Obviously, if it's defect, it would lead to the change control process. And the third one that we kind of see is misrepresentation on the scope of works and deliverables. And lastly, delays to the project and the critical path delays, missing milestones, etc. I would think in these type of disputes, you would need a specialist technology or IT project knowledge, and ideally from the whole legal team itself, whether it's the solicitor, counsel, or the arbitrator. But I know Gideon and Lucy will cover this in the next part of this session, so I'll leave it for them to further discuss. In addition, where there are breaches to these type of agreements that depend on a tech element, I would also say that specialist knowledge is also required. And we have seen breaches of shareholder agreements dependent on a milestone being met in an IT project. So whether such milestone would be met would depend on an understanding of the deliverables under this project and the project at large as well. So it's not just really that you can pinpoint set elements. And I think also in these type of claims, you would see the benefits of specialist knowledge. And looking at the second and third example you mentioned, I think we can probably do a whole session on gaming later, Gotcha, as well. But there is certainly a boom in the e-entertainment space globally, and that includes gaming and esports. We see a lot of investment in Europe, Ireland, UK, and also the US. And from a commercial perspective, agreements for the mobile applications, digital platforms, procurement, and also a compliant checklist on data and the use of cloud services would be beneficial for companies within that space, not to mention the growing use of NFTs. And what the audience will notice in the chart that Gotcha has is that cryptocurrency and fintech, there's still a small percentage right now, but these are emerging tech areas, and arbitration is suitable, mainly because of enforceability and confidentiality. Not to mention the expertise of the decision maker who will truly understand, for example, how the blockchain technologies work and operate. Having said this, there was one area that I was surprised not to notice in the pie chart, and it's not yet in the stats provided by HK45, and I think we'll see more of it in Hong Kong and Asia Pacific, and that is data. And by this, I mean claims related to data protection obligations of the data user and the data processor, and also in the case of data system breaches. And these can be as a result of employee or system errors. With more regulatory enforcement and fines and penalties attached, I think we'll definitely see more of this trickle down the contractual chain and disputes arising out of data. Over to you, Gotcha.
Thank you, Jennifer. Can we move on to the next slide, please? In this slide, we see the number of tech-related cases per year, and it's worth to mention that over the years, the tech-related cases, the percentage of tech-related disputes went over to 10% of our overall cases.
And I think looking at this table, Gotcha, as well, in the past 2 years, it's not surprising that there probably is an increase, given that there is a move into the virtual world, whether that is obviously linked to COVID. I think we'll all have our own views on that. But ultimately, there is an expanding use of technology and blockchain technology to help businesses become more efficient and connected. We are currently living in a virtual world, and this webinar also highlights that. And what we're observing from a private practice level is there are a lot of C-level discussions and boardroom discussions on improving efficiency via technology and digital transformation. There's also development in the e-commerce and e-payment space, giving rise to disputes and a changing legal and regulatory landscape. So Gotcha, what nationalities are the parties involved in technology disputes?
Can we move on to the next slide, please? Thank you. We observe that parties in technology cases are often from mainland China, Hong Kong, the United States, British Virgin Islands, Cayman Islands, Taiwan, South Korea, Japan, United Kingdom, Switzerland, and Singapore.
Yeah, so the top four is definitely not a surprise to us, and this will actually be further explored in our next event in the Tech Dispute series, where we'll look at obviously the China-US trade and the impact on dispute resolution. So more on that later this year. We've previously mentioned the Queen Mary report, and I'd like to make a quick reference back to that, which is 92% of the respondents to that report indicated that international arbitration is well suited for TMT disputes. And the attractive features that are enforceability, ability to avoid foreign jurisdictions, expertise in the decision maker, as well as speed and cost, and also confidentiality. Gotcha will now give us some HKIC stats for technology disputes and the benefits of using HKIC in such type of disputes.
Can we move on to the next slide, please? Thank you. Before I move on to the benefits of HKIC rules, I would like to quickly summarize the total amount in dispute, which is 37 billion Hong Kong dollars and approximately 4 billion US dollars. And 42% of the cases have amount in dispute over 25 million Hong Kong dollars. We also administer cases conducted under ancestral arbitration rules as well as HKIC rules. And we noticed that 73% of tech-related cases are administered under HKIC arbitration rules. Top 5 categories we've already mentioned are sale, purchase, corporate, IP, and telecommunication and media disputes. Next slide, please. So I'm going to cover a lot of items here. Please bear with me, and let's start with the left side of the slide. This is the pie chart that I wanted to share with you in relation to total amount in dispute. And we put 25 million Hong Kong dollars as the division point, since it is the threshold for expedited procedure at the moment. And as you can see, in 52% of the cases, the amount in dispute is below 25 million Hong Kong dollars. Since it is made available, it became a popular provision, and tech-related cases may be eligible considering this pie chart. So what the procedure provides you: fast dispute resolution, yes, and our courts and duration report highlights median and medium figures in relation to expedited procedure. According to the report, a total duration of a case conducted under expedited procedure is approximately 9 months, and it takes 6 months from transmission of the case file to the issuance of the award. And total amount in the total costs of arbitration is 51,000 US dollars. I must say that we closely track arbitrations conducted under the expedited procedure and the deadline. That said, we are aware that some tribunals requested additional times. This has happened in a few exceptional circumstances. And we closely track the arbitrations in order to avoid this circumstance. For tech-related disputes, expedited procedure is not the only benefit that HKIC rules provide. 24% of the cases involving multiple contracts and 37% of these cases involve multiple parties. Therefore, single arbitration under multiple contracts and consolidation provisions can be quite useful for these arbitrations and to increase efficiency and consistency. Another interesting thing to mention is emergency arbitrator. I know procedurally we are all aware of the procedure and the usage of emergency arbitrator, but when we focus on the merit side of it, one may ask what could be so urgent in a tech-related dispute. To date, we had identified 3 emergency arbitrator applications, and I would like to give you one example. This dispute arises out of a non-disclosure agreement, an NDA, pursuant to which claimant agreed to provide certain confidential information to respondent in respect of a potential licensing of medical technology, and respondent agreed to keep the licensed information strictly confidential. Claimant alleged that following the termination of the parties' transaction due to negotiation breakdowns, respondent has breached the NDA by misusing the confidential information. In its application, emergency arbitrator application, claimant requested the emergency arbitrator to order an interim injunction prohibiting respondent from making any further use of or accessing the confidential information. Last, but definitely not least, HK45 may be beneficial for seeking interim measures in PRC courts. As I mentioned earlier, parties from mainland China is frequently seen in the cases. Therefore, interim measures arrangement could be quite useful. Under the arrangement, any party to arbitral proceedings seated in Hong Kong and administered by HK45 or one of the other qualified institutions may apply to a competent mainland court for interim measures in relation to the arbitral proceedings. Mainland courts may order interim measures, including the preservation of assets, evidence, and conduct. To date, we received 60 applications, and 5 of them were related to technology disputes. 4 of them are administered under HK45 administered arbitration rules, and 1 of them is conducted under ancestral arbitration rules administered under the HK45 procedures. I mentioned this earlier in another slide, that we provide administration services for cases conducted under ancestral arbitration rules. All of these applications about tech-related disputes were about asset preservation. However, considering the technology disputes and the emergency arbitrator example that I just gave you, I think another relevant preservation could be conduct preservation. To date, we have observed 1 case where applicant filed a conduct preservation application. However, the court later treated this as an asset preservation. Jennifer, shall we move on to summaries, or would you like to comment on the points that I just made?
I think I'd just like to make one quick comment. That, the HK45 rules obviously brings a lot of useful tools in the event of technology disputes, and for this to be considered, parties should consider it when they're drafting the dispute resolution clauses. And if they're stuck for a template clause, then one is available in the HK45 administer rules for parties to insert into their relevant agreements. I think we've given the audience good introduction to technology disputes, and I know Gotcha, you'll be providing 2 examples before we close off the first part of the session.
Yes, shall we move on to the next slide, please? Thank you. So this is a case study that we provide for this presentation, and this is about a cryptocurrency dispute which is directly related to technology, and it is between a Hong Kong company and a South Korean company. The amount in dispute is 6 million Hong Kong dollars, and the issue is whether respondent breached the joint venture agreement that was entered into for claimant to provide currency services using respondent's technology. Over to you, Jennifer.
Great. I think some observations there in terms of, JV collaboration type disputes. These are also very common type of technology disputes, forming 39% in the Queen Mary report. The example sounds like a common case where one party is developing a technology solution for another party, obviously collaborating together. And the key to assessing whether there's a breach here is really understanding the scope and the deliverables to properly assess, where the obligations lie and which party have the obligation to do what. I think it is also important to manage the support and maintenance issues over the lifetime of the technology solution to be provided, such as the digital platform as well, and make sure that these are documented correctly in the contract. Practically, I think parties can also consider using the expedited procedures, as Gotcha has mentioned. The claim here is 8 million. So it is something that, parties can use this fast track procedure to make sure that they get an award, usually rendered within 6 months. Gotcha, shall we provide the next case study?
Yes, let's do that. So in the second case study, I wanted to give you some example about indirectly related, from the indirectly related cases category. Before I move on to the case summary, I would like to give you a background information. In this case, claimant and first respondent are in agreement to produce a certain type of speaker, and they enter into a loan agreement with the second respondent when first respondent allegedly had payment difficulties. And this case arises out of a tech funding arrangement, and the issue is whether respondent breached the loan agreement that the parties entered into for production of the said technology goods.
Yeah, and I think in these type of indirect cases, it's also critical for lawyers to understand how the technology works behind it all, and obviously how the technology funding works as well. For example, by focusing just on proving the case in respect of the loan agreement, you know, it can lead to detrimental evidence being reduced as well along the process if parties are not clear as to what is actually critical in terms of them providing that technology element of the contract. Also, I noticed that this is a case of 3 arbitrators. So here, I think at least one arbitrator should be someone with that specialist knowledge of technology, either technology industry or technology claims itself. Great. And I think.
Oh, sorry, this is all from me, and thank you very much for your comments on our insightful information, and we can move on to the next part.
Great, thank you, gotcha. I hope that this has given our audience an introductory start to what technology disputes is and further their understanding in this area. Just a reminder that there is a Q&A session at the end, so please type in any questions you want to ask in the Q&A box. And I will now pass over to Gideon and Lucy, who will discuss the procedural and substantive issues faced from the perspective of an arbitrator, Lucy, and also counsel, Gideon there. Over to you guys.
Thanks, guys. Before you, there is a Q&A that's come in already, Jennifer. Do you want it from Gizem Alper? Do you want to answer that now or come back at the end?
I think we'll come back at the end.
Very good. Thank you. All right. Well, thank you to HK45 for bringing us all together. We have a couple of topics to discuss, and the first question to discuss is whether or not you need a specialist arbitrator and or counsel for a tech dispute. And to give his views on this first question, I'm going to hand over to Gideon, and spoiler alert, we actually have slightly different views in relation to the answer to this question, so we'll try and keep it lively and controversial. No pressure, Gideon, over to you.
Thank you, Lucy. In some ways, there's a very quick answer to this. Yes. But of course, that's a simplification. As we all know, in law, the answer to every single question is, it depends. And this is no exception. When deciding which arbitrator to choose, if of course the choice is yours, if I were making the decision, there'd be 3 questions that I'd be asking. 3 things that would determine it. Firstly, what type of case is it? Is it a case in which the technology is critical? Is it a case which really is a legal case? Is it a case which really needs procedural complexities? Is it a case that really is going to involve very heavy factual disputes or projects or issues like that? That's the first question. Second question, who are the parties? What are the types of things that are involved in this case? Do they have any expectations as to what we want? Are they people that are going to expect a particular outcome, a particular approach to dealing with the case? Obviously, if you're dealing with parties that all speak French and are used to French law and are dealing with a Swiss-seated arbitration where everything is in French, you might not want to appoint a common lawyer from England or Australia who speaks only English and would need everything, but incur the cost of simultaneous translation, but also won't know who specialises in shipping law. That may not be your ideal arbitrator. And then the third question that's really critical is, are you going to win? Because fundamentally, when you're representing a client at least, the big question is what is going to maximize the chances of success? That's it. That's the only question. And if you appoint an arbitrator who isn't going to maximize it, when you could appoint someone who would, then you're appointing the wrong arbitrator. Now, of course, that's a slightly cheeky way of putting it, but in reality, that's our job. And how do you do that? Well, if you've got a great case, you want to appoint someone who completely understands the technology, is on top of the procedure, going to be very, very firm, and is a brilliant lawyer as well. And if you've got a terrible case, you want to appoint someone who's never done a tech case in their life, preferably has no experience with the law and no experience with arbitration, so that they're going to be totally lost. And you can bamboozle them with whatever rubbish you want, your client wants you to advance, obviously within the parameters of ethical acceptability. Now, sure, those are the extreme positions. But in terms of a normal case, what do I think, from my perspective, I would suggest are the critical points. Firstly, tech cases are different. Technology is a different industry. There are specialist legal points that arise in tech. There you may want someone who has an understanding of data laws, of IP laws, of contract law. Very often you want someone who's got contract experience and not someone who's got IP experience. They are different. That there may be some competition, antitrust issues. There could be all kinds of things, particularly if you're dealing with particularly complex cross-border stuff. You want someone also who's got experience of arbitration. It is horrific where you're dealing with counsel, or opposing counsel, or arbitrators who don't have the cultural background of being in arbitration, who don't really understand the way in which things are done, the significance of the rules, who aren't in a position to make submissions about whether or not you can refer things under multiple contracts under the same thing, or deal with jurisdictional problems. So three things that really, I would say, are the big points for tech cases. Number one, get a lawyer. Get a lawyer who's got experience of arbitration. Lawyers, just in general, make better arbitrators in tech cases. Lots of other cases as well, but not all. But in most tech cases, lawyers will make a better arbitrator. Ultimately, this is a legal dispute. It turns on what a contract means, or on what particular law means, and the lawyers are just a better place to decide that. Secondly, don't go for one of the great names in arbitration for your tech case, unless obviously they're a specialist tech great name. There are some of those, but in general, the great names in arbitration are not tech lawyers. They don't have experience of tech disputes. They have experience of very different types of cases, and they don't make the best arbitrators for tech cases. This is an area in which it makes sense to appoint an up-and-coming arbitrator who's going to want to impress you, who's going to produce awards quickly, and who's going to understand some of the terms and the issues that apply in technology in a specialist way. And thirdly, think about whether or not this is a case where particular experience is needed. Do you need someone who understands technology, particular types of technology? Technical issues, non-technical issues, commercial issues, project issues? If you need any of those, go for someone who does. It will make your life much easier in the long term. Lucy, I know that you have a slightly different view as to the importance of tech-specific experience, but I'm interested in hearing that.
Well, I agree entirely with your very perfect and apt for all answers as a lawyer, as it depends. So, of course, we agree all the factors that you outlined. Depending on the individual case, you'll choose the arbitrator that fits your individual case. I think, point of disagreement is how much emphasis you give to the industry expertise against all the other factors, and how essential is it for the person to have it. And we all are a product of our own experience. We speak through the prism of our own experience. So my experience as counsel and as arbitrator is that most disputes come down to commercial disputes, not investment treaty disputes, come down to the terms of the contract and the contemporaneous pre-dispute documents. There are exceptions to that. You know, sometimes witness testimony is important, sometimes there's credibility issues, but generally I want someone both as the counsel and as the arbitrator who can really get a firm hand on those two foundational aspects. And you know, also someone on the arbitrator sense who knows what they're doing in terms of a firm procedural hand. And there's also some strategy involved here, particularly if you're representing the respondent. Whereas if the claimant has appointed, let's call them an arbitration specialist rather than an industry specialist, as the respondent, you might want to appoint, as counsel to respondent, you might want to appoint the industry expert, because that person may carry more weight with the chair, the swinging vote, so to speak, on any industry issue that comes up. So you don't have that the benefit of the hindsight, so to speak, when you're representing the claimant. But for a 3-person tribunal, for the bigger disputes, I think that is something to think about, the tribunal dynamics. And on that point, I would also say, if you do have a 3-person tribunal, I would encourage you, not industry expertise is very important, contractual knowledge, arbitration expertise. For a 3-person tribunal, don't underestimate the importance of tribunal dynamics and personality. And you want to appoint someone who, ideally industry expert, arbitration expert, contract law expert, everything, who also can work well with 1 or 2 other members of the tribunal. Because if you appoint someone who's a bit prickly, it's actually hard. It's much harder to work with someone who's a bit prickly as a co-arbitrator than someone who will work cohesively. That's obviously something that you need inside expertise from people like Gideon or Jennifer to give you that inside scoop on arbitrators. And I guess the final thing I should say for both arbitrator and counsel, you really should appoint Gideon, obviously not for both in the same disputes, because of his background in tech world, both as arbitrator and as counsel. So I think we mostly agree on the appointment of arbitrator, but can we maybe just briefly talk about counsel? Are there any additional considerations in terms of appointment of counsel that you wanted to flag before we move on to procedure, Gideon?
I think it really depends on your case, but I would use a tech specialist. They'll know, they'll be able to present things. The big advantage of a tech specialist, particularly, well, really regardless, if you've got an arbitrator who understands the technology, understands the tech law, and you've got counsel that doesn't, and the other side appoints someone who does, the other side's counsel is just going to have so much more credibility in front of the tribunal. And if you have a non-specialist arbitrator, the dynamic's exactly the same. Because a non-specialist arbitrator is going to be relying even more heavily on counsel being able to explain in non-technical terms what for a non-specialist can be extremely complex issues, like the way that the internet works, or what a DMZ is in a IT security system, things like that, where if you've got a specialist, goes without saying they'll probably know that, or will look it up themselves if it's a particular thing they don't know. If you've got a non-specialist arbitrator, more often that they'll want counsel, and you'll be better served by getting counsel who has experience and is able to assist you in dealing with that. What's your view, Lucy, from a...
I do agree as counsel, and I think wearing my counsel hat, clients hate to pay for their lawyers to learn about their industry. They want to go to someone who already knows how their industry works. And my biggest practical tip for the younger lawyers who might be listening and watching while probably doing lots of other work, because I know how brutal it is to be the junior associate on the team. My biggest advice to you, I mean, the subject for today is Tech Disputes Demystified. Unless you did have a background in tech and had a degree in tech before you did your law degree, when you first graduate, you don't know really much about anything, and besides law, hopefully, but you don't know much about tech or any other industry. And my best advice to you, and even for the senior and mid-level lawyers, is to sit down with your experts, if it's a case that's big enough that you've got experts that you've retained, preferably without the client in the room so they don't see and hear the questions and you're not self-conscious about it. But ask all the dumb questions to your expert that you just don't know the answer to, that you can't get from Google. Get your expert to explain them to you, because that's the only way for you to demystify the dispute for yourself. And then that's how you can build up the expertise. Once you get taught once by an expert when you're a junior associate, that's how you can then build on that experience in the subsequent cases. But anyway, that was just my little practical tip for the younger lawyers on the room, in the virtual room. So
can I add a practical tip on top of that as well, which is also, if you're looking for great resources that might help you get there and improve your understanding, if you look at the profiles of people who in your firm, in other firms, in barristers' chambers, are arbitrators, practicing in this area, often that will link you to a whole load of other things, that articles that they've written, articles that other people have written, other resources, industry bodies, tech law bodies, which will have other presentations and other articles that give you a big insight into these areas.
Yeah.
I think we were going to move on to the question of substantive procedure and what specialist substantive procedure is important to take into account in tech cases. Lucy?
Thank you. Well, there's a myriad factors. I actually have 13, which don't panic. I'm going to go through them very quickly because Gokchi has already pointed out some of them. And in the interest of time, I won't bring up the relevant HK-IAC rules on the screen. I'll just refer them to you for your subsequent reading and reference to the extent you want to do so. The first is expedited arbitration. We heard Gokchi, that was a really interesting stat for me, that 52% of the HK-IAC cases are below the threshold for expedited arbitration of Hong Kong, 25 million, I think. And that's Article 42 of the rules. So for those of you who are counsel, if you have a dispute that's a smaller one, you have to apply for expedited arbitration. Me as arbitrator, or Gideon as arbitrator, we can't make it expedited. It's something that the counsel has to do before the tribunal is constituted. So that's the first factor. If it is a smaller dispute, think about expedited arbitration and make the application. And similarly, my second point is early determination. That's Article 43 of the rules. It's something that's a reasonably new innovation for HKIC and for all the institutional rules. We now have something like, it's akin to summary judgment in litigation in response to user feedback saying they wanted a mechanism for this. Again, I think this is something that particularly for the smaller disputes, it may be of interest for to apply for. Again, it's got to be something the parties apply for. So check out Article 43. The next, so I'm on point number 3 now, cantering quickly through. Interim measures. So that Queen Mary survey that Jennifer referred to found that there were 57% of the respondents said that injunctions were too hard to get in international arbitration, and that was an impediment to them choosing international arbitration for tech disputes, because as you all know, or as you may know, that often if there are issues of ongoing infringements or ongoing breaches, the damages associated with that can be quite high, or sometimes it can be harm that's not compensable by damages. So that's where you have an interim measures application, Article 23 of the rules, or potentially an emergency arbitration, again, as Gokchi referred to, which is Schedule 4. The fourth procedural point, and then I'll pause to see if there are any comments, is confidentiality. We know from our practice as counsel and or really as counsel, that confidentiality is incredibly important to most parties in arbitration, and particularly important actually in the tech sector. A lot of parties do want their disputes to stay confidential, particularly if there are trade secrets involved. Again, there's Article 45 of the HKISC rules that deals with confidentiality. So just make sure that you've addressed that in PO1. If the arbitrator doesn't include it, make sure you have an express confidentiality provision. Let me just pause there to see if Gideon has any comments before I go to my next batch of procedural mechanisms.
I think this is all gold, actually, Lucy. I don't really want to interrupt you because you're doing such an amazing job.
Awesome. All right, so where was I? So number 5 of my 13. E-case management or dispute resolution software. Unsurprisingly, tech companies are pretty tech savvy, and they like to see their tribunals and their institutions dealing with things in a way that's sensible for 2022. So HKIC now has Case Connect, and all the other institutions are doing something similar, maybe not as good as the HK Case Connect, but that's something that I think for tech disputes, there really is no excuse. Leading on to my next point, point number 6, for hard copies, for example, the old school way of paper bundles, there's just no excuse for that in 2022, particularly for smaller disputes the financial cost involved with printing and then posting, snail mail, but also the environmental impact. So there really, so that's my point number 6, no need for hard copies generally for tech disputes, again, particularly the smaller disputes. For smaller, number 7, smaller disputes, you might not have an expert, you might not have the budget for an expert. So for the 2 case examples that Gotchi and Jennifer gave, they're reasonably small disputes. It's not worth the expense of having an independent expert retained by the parties. So I would say in that situation, it's actually really important for your sole arbitrator or for your arbitrator to have that industry expertise. It's less important for the really big cases where the arbitrator will be educated by the experts retained by the parties. But for the smaller cases, going back to the initial discussion, I think you're less likely to have experts and therefore you want industry expertise. 7. Number 8, again, in the smaller cases, often in my experience, and certainly in the first part of my arbitrator career, about 50% of my cases involved respondents not participating. I don't know if that's been borne out by Gideon's experience as arbitrator and as counsel in tech disputes. I think that's just across the board for smaller disputes. For various reasons, the respondent won't participate. And there are special due process or procedural fairness considerations that apply to that will apply equally to tech disputes. So let me pause there after my next tranche to see any comments or objections or outrage from Gideon.
Still all gold. A couple of comments that probably just worth adding. Tech cases can be very technical. A lot of them can turn on expert analysis, need expert input. There are 2 things that are absolutely critical to do when a tech case comes in, and to do it as early as possible. And that will set you up for running, and if you're able to, winning the case. And if you don't do them, you will lose. And those 2 things are analysis. Do the analysis at the beginning, work out what is the case, what is the central point of contention, what are the things that you're going to need to prove in order to win. And the second is get the experts in if they're needed for your case, and make sure that the expert is going to support you. By that, obviously, I don't mean twist the expert's arm and say, well, I know that you're telling me we're totally wrong, but would you mind writing a report that says the opposite? I mean, getting an expert that actually does support you. And if you can't get an expert that supports you, telling your client, look, we might be in trouble here.
I totally agree. And I think there's practical considerations that's gold, Gideon, gold. And I think there's practical considerations that would come from that. One is, like, if it's a smaller dispute, you might not have the budget for an expert, and that's why you want your industry expert as your counsel. For the bigger cases, if it is a big case, $500 million US, big case, absolutely get your experts involved before you file the request for arbitration. So, and that's true for quantum experts and industry experts as well. I 100% agree with that. Okay, my third and final tranche, points 9 to 13. Point number 9, mediation. Tech disputes, parties are really into mediation in all forms of tech disputes. It was actually the most preferred mechanism for resolving disputes in that Queen Mary Pinson Mason survey. So as counsel, not as arbitrator, because it's not something that I consider appropriate for me to be encouraging the parties for mediation, although other minds differ on that. But as counsel, I think it is something that you should be suggesting to your parties, maybe drafting it in the dispute resolution clause, or even if it's not there, suggesting mediation as an attempt to resolve the dispute before arbitration. Point number 10, procedural point number 10, settlement. That Queen Mary survey again, 41% of tech disputes settle. That's about right. That's about consistent. The general rule of thumb in commercial disputes, about 50% settle. But the real interesting thing, at least for me, is in telco disputes, they're 81% likely to settle. And for IT disputes, 78%. That's a really high settlement scenario, and I think it goes with confidentiality and interim measures and the other points we've talked about. So it's really dangerous as counsel to run a case assuming that it's going to settle for reasons that is the subject of another webinar. But as counsel, you should also be aware that, at least according to the statistics, there are more likely to be settlement of these disputes, so you should make the overtures at the relevant time. Point number 11, just moving on to different mechanisms for tech disputes. HKIAC has the domain name disputes option. So if it is a domain name disputes within tech broadly defined, consider that. Point number 12, very briefly, third-party funding for smaller disputes, and indeed even for bigger disputes now. Many companies are turning to third-party funding, not just for small claims, for big claims as well. So there's just been changes to the laws in Hong Kong in relation to third-party funding. So think of that as counsel. And then my final point is 13, lucky 13, is we've been talking about commercial arbitration, but for tech disputes, be aware that you may have a parallel investment treaty arbitration claim. And I looked at the UNCTAD website, and there are, in fact, on my final, I'm going to try and share my screen just to see, just to keep you guys awake. Hopefully you can now see this UNCTAD website. Gideon, can you see my screen, the internet there? Yeah. So this is the UNCTAD investment policy website that looks at all pending investor state cases. If you do a search for, I think it's somewhat weird, it's that the terminology is information communications. That's the category, that there's no tech category, it's information/communications. And there's 80 pending cases, investor state cases. And if you look at them, a lot of them, it tracks those HKIAC stats, they're increasing. Tech disputes are going to investor state. These are obviously big ones. You can see there's a lot of telco cases, publishing activities, information services, domain name, etc. So be aware that we've been talking about commercial arbitration, but be aware that there may be investment treaty claims as well. So let me pause there, hand back to Gideon for wise words to wrap up, and then maybe we go back to Gotchi and Jennifer in relation to time.
I think that's an exceptionally helpful list of 13 points. My point really comes down to one point, which is there is no substitute for doing the analysis. There just is no substitute for that. And with a lot of the points that underlie Lucy's 13 points, doing the analysis is there's no getting away from doing the analysis and seeing, am I going to win? Is this going to win me this case? Is this going to, from a counsel perspective, of course, is this going to win me the case? But also from an arbitrator perspective, if someone makes an application, let's choose as an example an early determination. I've argued, the last one of these I argued was earlier this year. And the problem with an early determination, as I'm sure a lot of you will be familiar with from either early determinations you've done yourselves or summary judgment strikeouts that you've dealt with in courts, it's a really high threshold. Arguably, the threshold for early determination is even higher than the threshold for summary judgment or strikeouts in the courts. The threshold is in arbitration is manifestly without merit. And there's some investment treaty awards that suggest that's you've got to look at it and say, yeah, this is just obviously wrong. Well, there aren't that many cases in truth, other than the ones that just turn on the interpretation of a contract, or where someone is just saying something so bonkers that it's just so obviously wrong. And there aren't that many tribunals, frankly, that are desperately keen to dismiss cases by early determination. Obviously, you might have a case where it works, but a lot of cases, you're not going to win on it. So always think about it, but with some caution. Emergency arbitration, again, injunctions are something that come up again and again and again and again in the tech space. People don't like companies infringing their IP. Tech companies are based on IP. That's what it's all about. People don't like their licensees taking their software, reverse engineering it, and setting up a competitive product in breach of their license agreement and probably in breach of their IP, obviously. Are you going to get an injunction for that? That's a different question. And are you going to get an emergency injunction against that? Again, a different question. People don't like people terminating their ongoing projects or their outsourcing agreements. But are you going to get an injunction that actually makes them go ahead and do the work? There's also a lot of emergency injunctions that come up on the fringes of where a company is likely to go into insolvency, and people want to try and freeze various assets to prevent them from doing that. Or a lot of them that come up in the context of restraining someone from calling on a bond. What's the test in your jurisdiction for that? Or under the law of the contract, or under the jurisdiction? Can you argue bad faith? Is that an exception? Or not in your jurisdiction? Make sure that you have answers to all of those questions before making the application. And finally, these are great cases. These are all dead fun. You learn really interesting things in tech cases. They are a specialist area. They are a fascinating area. They're going to be an increasing area of work, I think, over the coming years. They're going to be an increasing proportion of the work. And even if you're not dealing with tech cases per se, tech issues come up in other contexts as well. Banking is underpinned by financial transactions are underpinned by a number of systems that run on IBM, that run on a series of mainframes around the world. Those technical issues do come up. People who are making payment frauds, there's a whole load of issues around that. Man-in-the-middle attacks, cyber attacks are affecting every industry. Infrastructure projects often have communications and control systems in them, and those raise a series of issues of their own. Energy systems, again, have a whole load of tech underpinning, particularly in the modern world. This is an area that's going to increase. It's a very exciting area. I hope to see you in many cases, either with me, against me, or in front of me in the coming years.
Thank you, Gideon. I couldn't agree more there. And thank you, Lucy and Gideon, for this very insightful sharing. We have one question that I do want to cover off before we end this session. Does HKIC hear disputes for patent infringements and patent piracy in tech areas? Gotcha. Can I hand it over to you to answer that?
Sure. We see patent infringement disputes, and on top of my head, I remember seeing it in our technology-related cases, and one of them was in relation to broadcasting and the broadcasting rights between two media giants, I would say, and the other one was in relation to patent of internet technologies from one jurisdiction to another. We listed them under the intellectual property category that I shared with you earlier when I was presenting my slides.
Brilliant, thank you. And we have another question, and I'll just read it out, and obviously, raise your hand if you want to answer it. Regarding the technology disputes with small value, how could most of the technical factual issues be dealt with in the arbitrations? Generally, how are the parties performing in presenting them cases?
I can answer that, or at least start answering that and then be corrected by Gideon, as the case may be. So I actually have had quite a few cases as arbitrator where the overall dispute is reasonably small in value, whether it's tech disputes or other disputes, such that the parties, it just doesn't, as I said earlier, it just doesn't make sense, economic sense for them to retain experts. And it's actually quite hard. And sometimes, frankly, in these cases, you don't have fantastic lawyers. They certainly don't have industry expertise. You don't have, four pump court or Pinsent Masons representing the parties. It's actually a real challenge. So in terms of, so usually it's just done through legal submissions from the parties, plus that contemporaneous pre-dispute documentary evidence, which is, in my view, really the most important part for most disputes, not all disputes, but for most disputes. So, and sometimes fact witness statements as well, because if they're in-house, there's no additional cost associated with using an in-house fact witness. But it is a bit tricky. And luckily, I've never needed to appoint a tribunal appointed expert, which I think would be tricky in these smaller cases, but it can happen. So that's in my experience. So parties do it through legal submission and fact submissions, not expert reports, because it's just too expensive. But Gideon, I'm interested in your perspective on that too.
Yeah, I think that I would agree with that completely. I think also the where it's an institutional arbitration, the institutions are very good at making sure that there's someone appropriate for the kind of case that's being advanced. In some cases, parties are able to agree joint experts. In a lot of cases, parties are able to just make submissions and put in factual evidence from people who are themselves really experts on what they're doing. And if you appoint an arbitrator who also has sufficient expertise, then things work out. But I mean, frankly, nobody thinks that for a $200,000 arbitration, you're going to get the same amount of investment on both sides, the same amount of money spent on arbitration as you do on a $5 billion arbitration.
That's totally true. It's not to say that the issues are any less complicated. Sometimes these cases can be just as complicated legally and procedurally as the $5 billion case, but you just don't have the array of experts and counsel before you. So it's one of the challenges I think most young arbitrators face in the first part of their career. Jennifer, I just have one. Oh, sorry, you go.
Yeah, I was going to add just a quick point from the practical kind of perspective is looking at obviously your factual witnesses and who would be best to cover kind of certain technical aspects as well. But ordinarily in these type of disputes, we'll definitely have a witness from the IT department frequently giving evidence, and obviously then the lawyers or guided by lawyers can go through how best to present this information in a witness statement.
Often in these smaller hearings, smaller cases, the parties have agreed that there won't be a hearing. So then you have fact witness testimony that you can't cross-examine on, which is just the reality of these smaller cases. And it comes down to the documents often supported by fact witness testimony. Just before we wrap up, I did just want to make a plug, and I hope this isn't crossing anyone's toes. There is this group called ArbTech. I don't know if you guys are familiar, maybe you're all members of it. You've got to apply to join. I've just applied, I haven't been accepted yet, so hopefully I do. And it is a group of lawyers who are committed to talking about tech issues in the context of arbitration, not tech disputes specifically, but if you're interested in tech and arbitration, I would encourage you to at least follow it on LinkedIn and to apply to join.
Great. Thanks for that, Lucy. And I would just like to thank all our speakers and our audience for joining us today. I hope the audience has obviously learned a lot more about technology disputes, and it's been demystified in terms of what is technology disputes and what do I need to consider procedurally and strategically when running a technology dispute. And hopefully we'll see you at our next event as part of this technology dispute series. Thank you, everyone.